In an era where digital transactions have become the norm, the European Data Protection Board, EDPB, released its Recommendations 02/2021 on the legal basis for storing credit card data to facilitate online transactions. This document is pivotal for understanding the delicate balance between user convenience and stringent data protection laws epitomized by the General Data Protection Regulation, GDPR. This article aims to unravel the complexities of these recommendations, providing a nuanced understanding for entities processing credit card data. The context: a digital economy under surveillance. The digital economy, bolstered by an unforeseen pandemic, has seen an exponential increase in online transactions, paralleled by a surge in cyber threats. The EDPB acknowledges this shift and the subsequent elevation in risks associated with online use of credit card data. Citing the Article 29 Working Parties Guidelines, the EDPB underscores the significant impacts credit card data violations have on individuals, including the risk of payment fraud. Hence, the recommendations stress the importance of implementing robust safeguards to protect data subjects and ensure their control over personal data, fostering trust in the digital ecosystem. The heart of the matter: storing credit card data. The recommendations specifically address the practice of storing credit card data by online service providers with the singular aim of easing future transactions for consumers. This convenience, while seemingly benign, poses several legal and ethical dilemmas under the GDPR framework. The document meticulously examines the legal basis under Article 6 GDPR, concluding that most do not suffice for the storage of credit card data post-transaction to simplify future purchases. The legal landscape: finding solid ground. The document elaborates that storing credit card data for facilitating subsequent purchases does not meet the criteria for necessary compliance with a legal obligation, vital interests, public interest, or performance of a contract under GDPR. Notably, the recommendations illuminate the potential for invoking the legitimate interests legal basis but clarify that this requires a balancing act between the controller's interests and the data subject's rights and freedoms. Given the sensitive nature of financial data, the likelihood of prioritizing data subjects' rights is high, placing consent as the primary viable legal basis for such data processing. Consent: the keystone of lawful processing. The EDPB posits that obtaining explicit consent from the data subject emerges as the most appropriate legal basis for storing credit card data for future transactions. This consent must be free, specific, informed, and unambiguous, obtained through a clear affirmative action distinct from agreements to terms of service or sales. Moreover, the recommendations stipulate that this consent must not be a precondition for transaction completion, ensuring that data subjects retain absolute control over their personal information. The right to withdraw consent. An essential aspect of these recommendations is the emphasis on the data subject's right to withdraw consent at any time, a process that should be as straightforward as granting it. This withdrawal must lead to the prompt deletion of stored credit card data, reinforcing the GDPR's principles of data minimization and subject autonomy. Conclusion: striking a balance. The EDPB's Recommendations 02/2021 serve as a critical guide for entities processing credit card data, delineating a path that respects both the convenience of digital transactions and the imperative of data protection. By advocating for explicit consent as the cornerstone of lawful data processing, the EDPB champions the rights of individuals in the digital age, ensuring their autonomy over personal data while navigating the complexities of the digital marketplace.